On February 24, 2026, in Thurston County, Washington, Judge Stilwell presided over an anti-harassment protection order hearing involving petitioner Tricia Malone, owner of a Mermaid school business called Ona Wahine, and respondent Tiffany Hagan, a former volunteer affiliate. The case arose from allegations that Hagan had misrepresented herself as an employee of Malone's company to secure performance gigs at festivals and fairs, allegedly causing Malone to lose business opportunities and damaging her professional reputation. Due to a conflict requiring recusal, Judge Stilwell first provided detailed legal instructions to all parties before turning the proceedings over to a judge pro tempore to hear the Malone v. Hagan matter.
To hear your matter, and in the meantime, we'll start with Kayleen Golden and Tyler Lord, pronouncing your name. I believe you're both on Zoom. But before we get to the specifics of your case, I do want to, for the benefit of all parties, kind of go over a roadmap for the hearings today. Mr. Laurie and Ms. Golden, I see you on Zoom, and as well Ms. Hagan, if you want to just make sure that you can hear me, okay, because I'm going to go over some of the roadmap from today. I see Mr. Laurie has activated his camera. Ms. Golden, are you able to hear me okay?
Yes, I can.
Okay, so we're here because a petitioner has requested an anti-harassment protection order. And what I want to do is begin with the legal definition of unlawful harassment, because there is a sort of a common understanding of harassment. Terms are also usually thrown in around stalking, things of that nature. And there's a very different, very specific legal definition of what it means to engage in unlawful harassment or unlawful stalking. And so I want to go through those first because when we hear the cases, the judge, myself, and then the judge pro tem will be returning to these factors as we go through the hearing. And we'll be asking questions around whether that legal definition is being satisfied. So what I'm going to do is I'm going to go through the elements of unlawful harassment. There are 6 of them. And then I'm going to sort of explain them in a little more detail that hopefully provides some clarity of what we're looking for. So here's the definition of unlawful harassment. All right, it's a knowing and willful course of conduct directed at without lawful or legitimate purpose that appears designed to alarm, annoy, or harass the petitioner, that would cause a reasonable person to suffer substantial emotional distress, and that actually does cause the petitioner to suffer substantial emotional distress.
Judge Stilwell began the hearing by explaining the 6 statutory elements of unlawful harassment under Washington law, emphasizing that this legal definition differs significantly from colloquial understandings of the term. Under Washington Revised Code Section 10.14020, unlawful harassment is defined as a knowing and willful course of conduct directed at a specific person which seriously alarms, annoys, harasses, or is detrimental to such person, and which serves no legitimate or lawful purpose. The statute further requires that the conduct would cause a reasonable person to suffer substantial emotional distress and does in fact cause substantial emotional distress to the petitioner. This statutory framework was established by the Washington legislature in 1985 and has been interpreted by courts to require a pattern of conduct rather than isolated incidents, as confirmed in Marriage of Fong, 1991, where the Court of Appeals emphasized the course of conduct requirement necessitates multiple incidents evidencing a continuity of purpose. Judge Stilwell specifically highlighted 2 critical elements that parties often misunderstand: the knowing and willful course of conduct requirement, which demands a pattern of ongoing behavior rather than a single incident, and the without lawful or legitimate purpose element, which requires courts to examine whether contact was initiated by the petitioner, whether both parties engaged in mutual communication, and whether the respondent had clear notice that further contact was unwanted. These elements are particularly significant in the Malone-Hagan dispute because the alleged misconduct involves business-related communications that Hagan may argue served legitimate commercial purposes, requiring the court to carefully distinguish between permissible competitive activity and harassing conduct designed to alarm or annoy. The statutory requirement of a course of conduct, rather than isolated incidents, serves as a crucial protection against the weaponization of protection orders in personal or business disputes, ensuring that courts issue these powerful remedies only when respondents engage in genuinely persistent, targeted misconduct that serves no legitimate purpose and causes real emotional harm.
Now, there's two elements that I like to spend a little bit more time on because it can be a bit confusing. The first is that first element, knowing and willful course of conduct. What that means is we're looking for a pattern of behavior. It is a very rare and specific situation where a single incident can form the basis of an unlawful harassment finding and the issuance of a protection order. There needs to be a pattern of behavior evidencing a continuity of purpose. So basically ongoing behavior directed at a purpose. The second element that I like to highlight is without lawful or legitimate purpose. So what we're looking for here are things like, and in at least the case I'm hearing today, the issue is really, is there contact for a legitimate purpose? And the factors that the court looks at on whether the contact is legitimate are things like, was the contact initiated by the respondent, by the petitioner? Was the communication dynamic in the sense that both parties are talking to each other, and it gets, for example, heated, and one at one point just decides this is, it's time for a protection order. Who initiated the communication, and what is it ongoing? Another factor we looked at is, has the respondent been given clear notice that all further contact with the petitioner is unwanted, but the respondent persists, and this is a question, frankly, I'll be having for the case I'll be hearing, is again, a lot of times when arguments will get heated, or people say, I would never want to hear from you again, things of that nature. What we're looking for the courts to get involved is, has there been clear notice that all further contact is unwanted, and contact persists in a way where, again, that further contact is not initiated by. Finally, we look at whether the behavior of the respondent has the purpose or the effect of interfering with the petitioner's privacy, creating an intimidating, hostile, or offensive living environment, things of that nature. So when we look at that legitimate purpose of the contact, again, the court's looking at sort of the context in which this can be. All right, so those are the elements that need to be satisfied, and those elements need to be satisfied by what's called a preponderance of the evidence. And basically what that means is the petitioner has to show that it is more likely true than not that the allegations in the petition are true. Is Allie? So I'm just going over this. So again, it's the petitioner's job to prove that it's more likely than not that the allegations in the petition are true. With all that said, that's sort of the roadmap we're looking at. How we're going to get there is the judge, again, myself or the pro tem judge, will call the case, call the parties up. There's one party here in person, the others are all on Zoom, and swear everybody in. So you'll be providing testimony under oath. The petitioner will go first, and then the respondent, and then the judge will issue a decision. Now, these are the statute governing civil protection orders contemplates that allegations and decisions are made primarily on the sworn declarations that are made here. And so testimony, in my view, every judge is a little different, but it's really more of an opportunity for the judge to ask questions of the parties. And so, don't necessarily come in thinking you're going to give a speech that's uninterrupted. Be confident that the judge has read your petition, has read the response, has read the documents, and be ready to answer questions about them. That's primarily what the hearing is for, in my view, is for the judge to ask questions to get to that answer. If folks have witnesses, live testimony is allowed if the judge finds that non-parties testimony is necessary and material to rendering a decision. Otherwise, you just hear from the parties themselves.
Judge Stillwell explained the preponderance of the evidence standard and the procedural framework for protection order hearings, noting that testimony serves primarily as an opportunity for judicial questioning rather than uninterrupted speeches by the parties. The preponderance of the evidence standard, requiring proof that a fact is more likely true than not, is the default burden in civil proceedings including protection order cases under Washington law, as established in Remarriage of CM 2015, where the Supreme Court clarified that this standard applies to all civil protection order determinations. Washington Court Rule 6.5 governs the admissibility of evidence in protection order proceedings, providing that courts may receive any evidence, including hearsay, that is relevant, material, and reliable, reflecting the legislature's intent that these proceedings remain accessible to self-represented litigants while maintaining fundamental fairness. The rule specifically permits courts to rely primarily on sworn declarations and written submissions, with live testimony serving to clarify and amplify rather than replace documentary evidence. Judge Stilwell's instruction that parties should be ready to answer questions about their submitted documents rather than deliver uninterrupted speeches reflects the practical application of CR 6.5, which allows judges to control the presentation of evidence to focus on disputed issues and avoid redundant testimony. This approach is particularly valuable in complex business disputes like Malone's, where the court must parse competing claims about employment status, gig bookings, and professional communications, factual questions that benefit from targeted judicial inquiry rather than narrative exposition that may obscure legally relevant details. The flexible evidentiary framework for protection order hearings balances accessibility for self-represented parties against the need for reliable decision-making, ensuring that courts can efficiently resolve disputes while maintaining the procedural protections necessary for orders that may significantly restrict respondents' constitutional liberties.
Kind of the last thing before I get the pro tem judge is, these can get really heated, these types of hearings. Each side is going to hear something from the other side that they vehemently disagree with, and that you think is probably full of lies and is being mischaracterized. I don't know anyone here, at least the case that I'm not recused on. The judge who will hear the case I'm recused on doesn't know anybody here. We just look at the petition and we hear the testimony. And so, to the extent that you think, oh my gosh, how is the judge listening to this other person, you may feel the need to butt in, kind of explain yourself, say that person's lying, that sort of thing. That kind of conduct's not tolerated. What you need to do is tell the judge, direct all your comments to the judge, tell the judge what you think happened. Be confident that when the other person is speaking, you will have your chance to speak as well. And so save your remarks to when the judge turns to you. Because if folks start interrupting each other, start shouting, start talking to each other, that's when these hearings get shut down and you will likely not get what you're asking. So it's really, really important, especially when these hearings get heated, to direct all of your comments to the judge and not to the other person. All right. So with all that said, we are going to actually begin with the case I'm recused on, because we do have a party here in person and the pro tem judge is ready to go. So I'm going to step off and go get the pro tem judge, and then we will proceed with Tricia Malone and Tiffany Hagan.
Right. Thank you. Please be seated. Good morning, everyone. Thank you for being here. I'm here to cover a conflict case, and I see respondent Tiffany Hagan on Zoom platform and Ms. Malone. You want to come to the council? Ms. Malone, Commissioner Stilwell gave information to all parties regarding the court protocols today and the court's expectation and definitions of harassment and then how the court proceedings will work. I see that in your case, let me try to stop. Case is 26000056. I see that you filed your petition on February 24th, and subsequently Ms. Hagan was served. Ms. Hagan, you want to turn on your video, please?
Yes, Your Honor. Thank you.
Do you say your last name is Hagan?
No, sir. It's pronounced Hagan, and it's misspelled in the document.
Okay, so is it with two G's?
No, sir. It's misspelled in the document. It's Hagen, Hagan.
That. Okay. So now that Mr. Hagan has been served, Ms. Malone, are you ready to proceed with your petition?
Yes, sir.
Okay. Do you both want to raise your right hand? Ms. Hagan also. Do you swear from the testimony that will be giving today will be truth, whole truth, and
Yes, Your Honor.
the petitioner for.
For a start, I just know that Ms. Hagan has been kind of harassing me continually through third party, through other vendors, and I have a mermaid school that I run, and she has been using my name and telling these potential people that I've already been talking to that she is running my promotions, is the word I'm looking for, trying to get us gigs when that's not, in fact, she's not an employee. She's just somebody that I had as a friend helping out, and that's how she paid for her certification, is by kind of helping me out when I certified her as a mermaid. And I heard from several vendors that I had been in contact with that she went behind my back and told them that she was setting up the gigs for us and got the gigs in her name. And then I went to contact them and they're like, oh, well, we already get, when I said, hey, I haven't heard from you about this gig. Oh, well, we already gave your company the gig. And I'm like, no, I'm the owner of the company. And they go, well, we gave it to Miss Hagan. And I was like, oh, it was Rose Downs is what they said. And I'm like, but she's not an employee.
So give me a little bit information on what this company is that you're referring to.
I run a mermaid school.
Mermaid school.
Yes.
How does that work?
I'm certified through the Professional Association of Diving Instructors. I'm required to have a business license and my own insurance. They require all that. Aside of, I work for the YMCA, so they have insurance on me, but I have to provide my own and the business license. And when I go and try and get gigs at Renaissance festivals and fairs and private gigs and such, and if they come to me and say, somebody comes to me and say, hey, I need a couple mermaids for this show, I will go to my community of mermaids and mermaids that I have certified. And I will say, okay, this person's looking for this in particular. I gave them a bunch of pictures, their backgrounds, and I will be like, they picked you and they picked you. And I will say, this is what I'm offering to pay you, as the owner of the company. And if they accept it, great, we set it up. And then they are paid through my company to do, I'm gonna say like a 1099. They're their own contractor, but because they're not a full employee. And I just set it up to where they're doing the gig, because certain people are looking for certain types of mermaids, and I may not be their type. They may want a long-haired, as Tiffany, redhead. They may want a really skinny person. They want a man, who I have a few mermen on my roster that I can use. So we get these gigs. Well, I've heard back from a few companies that Ms. Hagan has gone, after I've contacted these people, has gone in and said, oh yes, I'm working for Ono Wahine, which is my company, and I'm trying to get these gigs set up. And then she's booking the gigs for herself privately and getting paid privately through these companies. One of them was the Thurston County Fairgrounds.
Was in your employ as
she was not an employee ever. She was just a volunteer.
Okay.
Just somebody that came in as a volunteer. And we had an agreement that she would volunteer and help me out as payment, kind of like for, I do certifications for mermaid certifications through Patty. And in order to get her certification, she kind of like, I'm going to say, just kind of volunteered her time to help me out. And I just my fee would be, and she paid the Patty portion because Patty has their own fees to do the certification papers. So she just kind of helped me out. Yeah. But she was never a paid employee. And I never said she was, and she was going out getting gigs for these, supposedly getting gigs for these people. She would, I guess, send them letters in my behalf, which I've never seen the letters. I never approved of any letters. I've been contacting these companies, and there's a couple that we have lost out on because she has gone behind my back using my information. And now my name is blacklisted. So I'm losing money because, and I'm losing gigs, professional gigs, because I have somebody using my name saying that they're, oh yes, this is Ona Wahine, she's insured, and they're getting the gigs for themselves under my name. So when the lady at the Thurston County Fairgrounds, when I contacted her, she was under the understanding through Tiffany that she worked for me, but she didn't. So she gave her the gig assuming that it was my company, with the assumption that it was my insurance, my business license, but I had no knowledge.
After Judge Stillwell recused himself and a judge pro tempore took the bench, the parties were sworn in and petitioner Tricia Malone began her testimony, alleging that Tiffany Hagan had repeatedly misrepresented herself as an employee of Malone's Mermaid School to secure performance bookings from vendors. The doctrine of judicial recusal, codified in Washington Code of Judicial Conduct Rule 2.11, requires judges to disqualify themselves when they have a personal bias concerning a party, have personal knowledge of disputed evidentiary facts, or when their impartiality might reasonably be questioned. When recusal occurs, court rules authorize the appointment of a judge pro tempore under Washington Superior Court's Civil Rule 53 and RCW 2.08.180, which permits a retired or visiting judge to preside over matters when the regularly assigned judge is unavailable or recused. The use of pro tempore judges is particularly common in protection order proceedings, where statutory timelines require prompt hearings under RCW 10.14.80. Full hearings must be held within 14 days of petition filing or 5 days of service, whichever is later, creating pressure to maintain judicial continuity despite conflicts. Judge Stillwell's recusal and the seamless transition to a judge pro tempore demonstrate the court system's mechanisms for ensuring impartial adjudication while meeting statutory deadlines. The pro tempore judge's immediate confirmation that he had received Judge Stillwell's procedural instructions and legal definitions ensured continuity in the parties' understanding of the applicable law, while his fresh perspective on the factual disputes, unburdened by any prior involvement, preserve the impartiality that due process requires in proceedings that may result in significant restrictions on Hagan's liberty and professional activities. The recusal and pro tempore appointment procedures protect both the reality and appearance of judicial impartiality, which is essential for public confidence in court decisions and for the constitutional due process rights of parties whose personal and professional lives may be substantially affected by protection order rulings.
And after I talked to Kristen personally, because I don't like dealing with text and email, I said, let me call you. Let's explain the situation. Let's see what's going on. I said, please contact me as I'm the business owner. I don't want you dealing with somebody else that's not an employee. So she started dealing with me direct. And that's when she explained to me that Tiffany had gone to her and used my name, used my company to get herself a gig for tomorrow, actually. And
so your company, where is that company located? Is that in your?
My company home is based in Rochester, but I am based at the YMCA, at Briggs YMCA. I work for the company and I run my school through them. And I run my school through all of Washington.
Okay. So your allegation that she was using your name to get those gigs.
Correct.
Were those, which county were those in?
It's been Thurston County and what is Seattle, Pierce County, because it was the aquarium up there. Okay. Grays Harbor County with Graves Haven Renaissance Festival, the Portland Zoo also. These are different companies that the Children's Museum downtown, the Yacht Club downtown, the Grays Harbor Boat Festival, and the Grays Harbor, the one we did, Harbor Days.
So you're saying that she used your company's good name, your insurance information, and then got basically the
trying to get them for her.
The petitioner, a Mermaid school owner, testifies that the respondent used her business name and insurance credentials to secure performance gigs across multiple Washington counties without authorization, causing professional and financial harm. Under Washington Revised Code Section 9.16.035, criminal impersonation in the second degree occurs when a person falsely assumes the identity of another with intent to defraud, causing financial or legal injury. Additionally, RCW 1930-2020 addresses identity theft, when personal or business identifying information is used without permission to obtain goods, services, or credit. The Washington Supreme Court in State v. Maroney, 2017, clarified that identity theft requires only that the defendant knowingly obtained and used identifying information without consent, not that the victim suffered actual monetary loss. The petitioner's allegations describe textbook unauthorized use of business credentials, specifically company name and insurance information, to secure employment opportunities across Thurston, Pierce, King, and Grays Harbor counties. If proven, this conduct would satisfy the elements of both criminal impersonation and identity theft under Washington law. The respondent's alleged pattern of using multiple aliases, Rose Downs, Mermaid Lava, Tiffany Hagan, to contact venues further supports the inference of intent to deceive and avoid accountability. Small business owners, particularly in specialized entertainment industries, rely heavily on reputation and insurance credentials to secure contracts. Unauthorized use of these assets not only causes immediate financial harm, but can create lasting liability exposure if incidents occur during performances fraudulently booked under another's coverage. Courts must carefully evaluate such allegations in protection order proceedings because the pattern of conduct may indicate ongoing harassment, even when individual acts appear civil in nature.
She got a couple for herself, and then I lost out on the others because of all the drama. They didn't want to deal with us.
Did you contact law enforcement for your identity being used?
I had tried to, but they said I had to just do this. So I contacted him and they said, well, there's nothing we can do. It's a civil matter. So that's why I took it. One of my mermen has been harassed continuously as third party because of this whole issue. He's here with me as a witness.
So when you're referring to a mermaid, you're referring to a person,
A human being,
that,
yes.
that human being that acts like that for an exhibition?
Correct.
Okay.
Yes, for shows, right now we're doing a show at the Mermaid Museum and we're there.
So you said that allegations that she has used those. Are there any documentation to prove?
The document that I have from the Thurston County Fairgrounds is the text that I received that says that, because I didn't have, like I said, I talked to her in person because I wanted to know what's going on. And I don't like the paper of, like with texting, things get misconstrued. So I wanted to physically talk to her and say what happened. You know, it's easier for me to say on paper and it's just somebody says, oh, well, that's not what it was. It's easier for me to talk to somebody in person. The lady at the fairgrounds just has letters that says she's calling Rose to discuss it, send her information, and that she's said that somebody was threatening her, but there wasn't a threat to her. It was Mermaid Orion. The only threat was, if you don't leave us alone and stop using my information, you will be sued. That was the threat.
Who made that threat to who?
The petitioner explains that law enforcement declined to investigate her identity theft complaint, characterizing it as a civil matter, and she describes a threat to sue as the only communication that could be construed as threatening, raising questions about what legally constitutes harassment versus protected speech. Under Washington Revised Code Section 10.14020, harassment requires a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses and serves no legitimate or lawful purpose. Critically, the Washington Supreme Court in State v. R.W. 2019 held that threats to pursue legal action, standing alone, do not constitute harassment because they serve the legitimate purpose of enforcing legal rights. Similarly, the Ninth Circuit in United States v. Castle 2015 recognized that litigation threats are protected petitioning activity under the First Amendment, unless they are objectively baseless and made with subjective bad faith. The petitioner's admission that the only threat was, if you don't leave us alone and stop using my information, you will be sued, presents a significant legal hurdle for her harassment claim. Under R.W., this statement appears to be a legitimate demand to cease unauthorized use of business credentials, coupled with a threat of civil litigation, a protected form of speech. The court must distinguish between genuinely threatening communications and constitutionally protected demands for legal compliance, particularly where the underlying conduct, unauthorized use of business identity, may itself be tortious or criminal. Protection order courts frequently encounter situations where parties characterize legitimate legal demands as threats or harassment. Misuse of anti-harassment statutes to silence protected speech or retaliate against legitimate legal claims undermines the statute's purpose and burdens courts with disputes better resolved through civil litigation. Judges must carefully scrutinize whether alleged threats are actually unlawful intimidation or permissible assertions of legal rights, as conflating the two chills constitutionally protected petitioning activity and may expose petitioners to liability for malicious prosecution or abuse of process.
And so she wanted to clearly speak to me before, and I was working, so I didn't get the message. And then it came back that I said from using my business name to gain jobs, the casino, etc. Find the one that she says, I will give you a call. And that's when I physically talked to her. She goes, her one thing is, by the way, I received a visit from Rose on Monday at work. Oh, this was me. She visited me at work without my permission while I was teaching. And she showed up trying to discuss everything that was going on. And her stating that you and her talked almost daily and you two are very good friends. I said I had purposely not responded to any text. I wasn't trying to do any of this. I just wanted her to leave me alone. Leave my business alone. Leave me alone. Leave. She's hurting my business. I just wanted it to be gone and be done. So I ignored her. She showed up at my work. She also sent threatening letters she sent different names. She sent letters to the YMCA about the letters that Orion said about protecting me, leave me alone. And I almost got fired because they thought I was involved in it. And so I got called in the office and they said, do you know what's going on? And I explained, I said, because we've received several letters regarding some things that are really disturbing. And I said, and before they even told me who it was, I said, let me guess, either Rose Downs, Mermaid Lava, or Tiffany Hagan. And he looks at me and goes, yes. And I said, it's the same person under 3 different aliases. And that's what she's been doing to these different companies, is going under different aliases, using my information, trying to get jobs, showing up at my work, contacting multiple mermaid friends of mine. One I have a letter from that she immediately contacted her and was harassing her. It's like, now I have to step back as a friend because of things that are going on. And I don't want her contacting the people that I work, mermaids that I've used in the past, or any of my people that I know that are mermaids that I could say, hey, I might want to use you for a gig. They aren't going to want to work with me because of all the harassment, because it was constant emails and texts and phone calls back and forth. I never went to anybody when there was an issue. I was just trying to let it go and leave it alone. I didn't go to my friends. I didn't go to Orion. I didn't go to anybody. I just let it be.
The petitioner describes an escalating pattern: unannounced workplace visits, letters sent to her employer, YMCA, using multiple aliases, and third-party contacts with her professional network, all of which she claims damaged her employment and business relationships. Washington courts recognize that harassment through third parties, sometimes called stalking by proxy, can satisfy the course of conduct requirement under RCW 10.1420 SWETH, when the defendant intentionally uses intermediaries to circumvent direct contact restrictions. In Marriage of Fong, 1991, the Washington Court of Appeals held that indirect harassment through friends, family, or colleagues constitutes actionable conduct if it would cause a reasonable person substantial emotional distress and serves no legitimate purpose. Additionally, under RCW 9A 46.110, criminal stalking includes repeated harassment that causes reasonable fear of injury to person or property, with enhanced penalties when the conduct interferes with employment or business operations. The alleged workplace visit, without my permission while I was teaching, combined with letters to her employer that nearly resulted in termination, presents stronger harassment indicators than the litigation threat discussed earlier. If the respondent used multiple aliases to contact the YMCA and professional colleagues, this suggests intentional evasion of accountability and potential intent to cause professional harm. The Fong standard would ask whether a reasonable mermaid performer in this niche industry would experience substantial distress from having their employer contacted by someone using false names to discuss personal disputes. Likely yes, given the precarious nature of entertainment employment and YMCA's apparent zero-tolerance approach. Workplace harassment through employer contact is particularly damaging because it exploits power asymmetries. Most employees cannot risk their livelihood to accommodate personal disputes. When anti-harassment statutes were expanded in 2020, the Washington legislature specifically noted that economic harm through employment interference is as damaging as physical threat. Courts must remain vigilant against weaponized workplace complaints while protecting legitimate victims whose professional standing is deliberately undermined through deceptive third-party communications.
I started getting all these phone calls from all these different people, including the lady at the fairgrounds, saying, what is going on? Why are we getting all these harassing phone calls and constant texts and from Orion and Mermaid Koi and Mermaid Jess and the lady at the fairgrounds in Grace Haven? They were getting all of these messages and all of these emails. My work,
When you're saying they were getting, it's the third parties, other
the
people.
third party, and they aren't going to want to work with me because they're being harassed about a situation that had nothing to do with them. If that makes sense, if they're being harassed about me through them, they're not going to want to work with me, which is hurting my business. I'm losing jobs. That's my income. I've already lost the Seattle Aquarium, will not work with us anymore because of this issue. The Portland Zoo, the Children's Museum downtown, which I have worked at, the Boat Festival, Harbor Days, and the fairgrounds. And I finally got that one straightened around where I might have a gig, but I did lose out on a different gig with her because of Tiffany. I can't be harassed. She also has been stalking me and Orion Bolt on Facebook. She blocked everybody as soon as everything happened and she got served. She blocked everybody. She turned down her social media. Nobody, everything's done. Everybody was blocked. She can find me. She can unblock for a minute, find me, and then reblock. I don't go into her stuff, so I have no idea what's going on. I don't care what she does. I just want her to leave me alone. But she found out that my father died. I didn't tell her. And she's going around telling other people.
You told me in your protection order.
I didn't say anything. My father was sick. But I never told anybody except for I made a post on my Facebook that said, my father has passed. So the only way that she would know personally is if she was stalking me and going through my stuff to find that out. Because I'm not telling her I wasn't talking to her.
You said she turned off her media and she
all of her
blocked
social
you?
media got turned down. Her Instagram,
How
her
is that
Facebook,
harassing
her,
you?
huh?
How is her blocking her social media as in harassment to you?
No, I didn't say that was harassment. I'm just saying that she turned it off as she didn't want me to see what she's posting. I don't know if she's posting.
The petitioner pivots to social media stalking allegations, claiming the respondent accesses her Facebook despite blocking her, learned of her father's death through social media monitoring. And the judge immediately questions how blocking constitutes harassment, revealing potential weaknesses in this portion of the claim. Under Washington Revised Code Section 10.1402001C, electronic surveillance and monitoring can constitute harassment when it causes substantial emotional distress, but the Washington Court of Appeals in State v. Rehberger, 2016, held that passive social media viewing without contact or interaction does not satisfy the course of conduct requirement. The court emphasized that harassment statutes cannot transform constitutionally protected observation into criminal conduct. Furthermore, in Remarriage of CM, 2015, established that parties in disputes may view publicly available social media content without creating harassment liability, though using that information to contact third parties or make threats may cross the line. The judge's skeptical question, how is her blocking her social media as in harassment, exposes a critical gap in the petitioner's theory. The respondent's alleged conduct, blocking the petitioner, potentially unblocking to view content, then reblocking, describes defensive privacy measures rather than harassment directed at the petitioner. The father's death information came from a post on my Facebook that was apparently public or semi-public. Under Rehberger and CM, viewing public social media content, even by someone the poster dislikes, is not harassment. The petitioner's admission that I don't go into her stuff actually undermines her claim. She cannot establish a pattern of unwanted contact if she is unaware of and unexposed to the respondent's social media activity. Social media has complicated harassment jurisprudence because users often misunderstand privacy settings and then feel stalked when unwanted viewers access content they technically made available. Courts must resist expanding harassment definitions to include passive observation, which would chill legitimate speech and create unmanageable liability for millions of social media users. However, the line blurs when information gathered through social media is weaponized, used to contact employers, spread rumors, or coordinate third-party harassment. Here, the petitioner's strongest claims remain the workplace and third-party contacts, not the social media monitoring. which appears to be a constitutionally protected, if unwelcome, observation of voluntarily published information.
Bad things about me. I do know that she's going to everybody and telling them personal stories about what she believes that she wants to believe about the company. I'm not going to these people. I'm not going to anybody. They're messaging me or calling me and saying, what is going on? This Tiffany person has been constantly calling me and texting me, and they're like, I don't want to be involved in this. And I'm like, I don't want you to be involved in it. I don't know. I didn't say anything to them because I didn't want this to escalate into this. I just wanted it to disappear. So I had, like I said, I had ignored her for 3 days after I found out what she did at the fairgrounds. And then I found out with I started calling and saying what's going on to these different festivals. And they told me what was going on with her using my name and using my company name and saying that she had the insurance and that we were covered. And I don't think that's okay. It hurts my business.
You said that she has been stalking you. Can you give me an example?
She's been telling everybody about the incident on New Year's. There was her and another mermaid worked the New Year's gig at the Tilley Casino. And there was an incident and I was there the entire time supervising. So I had 2 mermaids and me standing in between, watching everything that is going on. This is New Year's Eve. This is at a casino. People are extremely drunk, and our mermaids are wearing tails, and they're put in chairs almost in a pathway. One of the men that was extremely drunk came in, tripped over her tail and fell. He got up, he apologized. She told me what happened. I had eyes on her the entire night. I was over there helping. We also had another man come over and stand next to her to help escort people around her. I talked to security. I informed them of what happened. My other mermaid that was there was a witness that happened one time. When I confronted her, I asked her about it. And because Tiffany was causing drama towards what was going on with the other mermaid, just kept spam texting her and calling her after the event, and had thought I had taken care of the situation. I was literally there the whole time watching the whole event. Nothing else happened. After the event was over, she contacted the event director instead of coming back to me and said it happened several times. I knew about the one incident. I took care of the incident. And that was it. It was done. I informed the security. I assume the security informed the event director because of what happened. Apparently that didn't happen. So I contacted the event director. The event director told me that Tiffany had gone to her behind my back and told her that it happened several times, which in fact it didn't.
The petitioner describes a New Year's Eve incident where she claims the respondent misrepresented a single drunk patron's stumble as multiple incidents to the casino event director, allegedly to extract compensation and damage the petitioner's professional reputation, presenting this as evidence of a pattern of deceptive conduct. Under Washington tort law, defamation requires a false statement of fact communicated to a third party that harms the plaintiff's reputation. The Washington Supreme Court in Taskett v. King Broadcasting Co., 1986, held that statements of opinion are protected, but false assertions of specific events, like claiming multiple safety incidents occurred when only one did, are actionable statements of fact. Additionally, RCW 9A 76.175 criminalizes making false statements to public servants, though this applies only to official proceedings. In the employment context, Gardner v. Loomis Armored Inc. 1996 established that intentional interference with business relationships through false statements can give rise to tortious interference claims, requiring proof of intentional and improper conduct that induced a breach or termination of business expectancy. The petitioner's allegation that the respondent told the event director it happened several times, when I was there the whole time watching and nothing else happened, if proven, would constitute a false statement of material fact capable of defamatory meaning in the close-knit mermaid entertainment industry. The alleged purpose, obtaining a free night stay and some gambling money, suggests commercial motivation that could support tortious interference if the casino reduced or terminated its business relationship with the petitioner based on misrepresented safety concerns. However, the petitioner's own admission that she assumed the security informed the event director reveals potential gaps in her knowledge. If security did report concerns independently, the respondent's statements may have been partially accurate or at least not knowingly false. Protection order proceedings are not designed to adjudicate complex tort claims like defamation or tortious interference, yet petitioners frequently present such allegations as evidence of harassment. Courts must distinguish between 1. Genuinely harassing conduct that serves no legitimate purpose, and 2. Disputed factual representations made in pursuit of legitimate interests here, presumably workplace safety or compensation for injury. The respondent's casino complaint, even if exaggerated, may have been a good faith dispute about working conditions rather than harassment. Conflating commercial disputes with personal harassment risks, both overburdening protection order courts and depriving respondents of full adversarial proceedings that tort claims would require.
I was there the whole time watching, so I knew it didn't. And said, well, I'm not going to press charges, or I'm not going to sue. And she ended up getting a free night stay and some gambling money from it, from what I understand. It kind of like, I want to say extortion's not the word I'm looking for, but she went to that person and then took it to the other, to Mermaid Coy, who had nothing to do with New Year's, absolutely nothing. She had messaged her, and that's in here. Sent me a little, an email that said what happened. She blocked Rose because she kept getting harassed by her. She did say that. She wouldn't stop calling and texting her about the incident on New Year's that had nothing to do with her. Mermaid Jess, the other mermaid that was there New Year's, kept getting texts and calls from her, and she wants to stay Switzerland. She said, she goes, I saw the one's incident, never happened again. I don't want to be in the middle of any of the drama. I just want to stay out of it. I respect that. I don't want my business to suffer, and it has.
Thank you. I understand your position now. I may have few more questions, but let me hear from Ms. Hagan now.
Okay, I do have my witness if you have any questions for him. He did do some police reports about the stalking and
You have explained enough. I don't see any reason.
Okay, but I wanted to give that option if it was necessary.
Thank you, Ms. Malone.
The respondent concluded her testimony by describing her volunteer work with the petitioner, her efforts to obtain video evidence to disprove criminal allegations, and her public performances at Irish and Celtic cultural festivals. The judge then intervened to stop further testimony, questioned the petitioner about alternative remedies, and began articulating the legal standard required for an anti-harassment protection order. Under Washington Revised Code Section 10.14040, an anti-harassment protection order requires the court to find by a preponderance of the evidence that the respondent has engaged in unlawful harassment, defined as a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses and serves no legitimate or lawful purpose. The statute explicitly requires intent. The respondent must know or reasonably should know that the conduct will intimidate or harass. This distinguishes civil protection orders from criminal stalking charges under RCW 9A46.110, though both share this intent element. In State v. RW 2019, the Washington Court of Appeals emphasized that protection orders are not meant to resolve ordinary business disputes or interpersonal conflicts lacking the requisite statutory elements of harassment. Here, the judge identified the critical gap in the petitioner's case. While the respondent's conduct may have caused financial harm, reputational damage, and emotional distress, the petitioner failed to establish the specific intent required by RCW 10.14040. The respondent's actions blocking social media, publicly disaffiliating from the business, and performing at culturally themed festivals arguably served legitimate purposes of self-protection and personal expression. The judge noted that even contacting third parties about business matters, while potentially annoying, does not automatically constitute harassment without proof of intent to intimidate. The petitioner's admission that she sought no damages and simply wanted to be left alone underscored that her remedy might lie in tort law rather than the protection order statute. This exchange illustrates a fundamental protection against abuse of civil protection orders. Courts must rigorously apply statutory elements rather than simply resolve disputes between feuding parties. Without this safeguard, protection orders could become weapons in commercial conflicts, subjecting individuals to criminal liability for conduct that falls short of true harassment. The judge's careful parsing of intent versus impact preserves the integrity of a legal remedy designed for genuine safety threats, not business disagreements.
Hagan, go ahead.
Hello, Your Honor. So in June of 2025, I became an affiliate with the Port of Olympia. I decided one day while walking around the harbor with my family, we needed some kind of children's entertainment down at the port. And I believed that mermaids would be a great, accessible, entertaining event for parents to come to. It would be a great opportunity for families of low income to have access to quality educational entertainment in our city for free. I met with the Port of Olympia's market managing and advertising guy. His name's Tabor Lee. We decided that if I could find someone who had the equipment to throw a mermaid show at Olympia Harbor Days in August of 2025, that the city would allow me to do it. It was a big public effort. We were all learning about permits, water usage, water access in our city. How are we all going to make this happen? And it was honestly one of the most warm community efforts that I've been embraced by since moving to Olympia, Washington. I found Trish Malone and in July started helping her build her mermaid tank, where I have, helped with painting it, the cost of the paint, pieces for the mermaid tank. And I spent time doing physical labor, like she said, in exchange for my PADI certification. Instead of making payments for the classes she provides, I was helping her build the tank, and then I would be performing with her in the summer and helping her again inside of her classes at the YMCA. That began in July. August was Olympia Harbor Days. That was the 28th, the 29th, and the 30th. I performed with her for free. She was allowed the spot at Harbor Days for free by the nonprofit organization. And we were allowed to have water access thanks to the Port of Olympia covering the service fees for us. It was a lovely show. It was honestly some of the most beautiful memories that I'll ever have. And I can't wait to continue to do that with my life. I think that that's my calling. Now, moving forward, I'm starting to volunteer in these classes where Miss Moan teaches at the YMCA. This is where things become a legal issue because Patty, who is the scuba board nationally that you get certified to scuba dive, free dive, and mermaid dive through, they have regulations that have to be met. And the witness that Trish brought today, how she said right before I began to speak, they had filed their own protection order against me that was denied by Kitsap County. Now, we're both volunteers at this establishment. Neither one of us get paid to do this. We're in the pool with these children, teaching them how to swim with their legs bound in a mermaid tail. However, I was new. I didn't have any kind of regulation from Patty to be certified or qualified to be in the water with these children. It's seen as a danger. I'm also not certified or qualified in lifeguard training through the YMCA or anyone else. And after I found out that I was breaking laws, rules, standards of national scuba, certification, I reached out to them and I said, I would like to understand what I'm legally allowed to do in the water and what I am not allowed to do, because I don't want to lose my certification to continue my career because I'm being misguided by the person I'm trusting to provide me a service. I made that phone call February 9th. That was the last day I saw Trish Malone. And that was my 30th birthday. So I thought seeing my friend would be something that would be all right. We had the protection order and the harsh words from her witness happen. She told me weeks before that her father was on hospice. I did not know her father had died until I received it in her own handwriting on her protection order. And I, on the 30th, I went up to the YMCA. I hugged Trish and I said, hey, nobody's words are more important than yours. If you didn't say it to me, I don't believe it. I wanted to make sure we are okay. I know that you're going through a hard time with grief. I'm here for you, my friend. And then I left. And then I, on the 11th, I find out that Orion, her witness, had filed that protection order. On the 12th, it's denied by Kitsap County, and on the 19th, it arrives at my house. And I'm shocked by the content.
Talk about that. That's not relevant. That's a different issue in a different court. So
yes,
continue
sir.
with what Ms. Malone has alleged.
Yes, sir. So on the 21st of February, I get a phone call from the Olympia Police Department alleging that an employee at the YMCA is saying that I'm contacting their work to harass them. But when I received that protection order, the reason that I bring it up is because I was accused of a crime in that protection order that happened allegedly inside of the YMCA facility. Now, I reach out to the YMCA and I say, hey, I was accused of a crime here by one of your employees. May I please have the video surveillance footage to prove that I did not commit this crime? YMCA tells me you have to file an incident report and a police report. We're not allowed to give that footage to civilians. So I do. And that's when Miss Malone has said I'm contacting her work and harassing her. That was implications of the YMCA due to the accusations that were made by her and her friend in the protection order at Kitsap County. And that protection order, they say I made threats, that I was yelling and screaming and endangering children, which is a big deal when your job is surrounded by providing a safe, entertaining space for children. The police department, as of the 25th of February, hadn't maintained that footage. They weren't able to go get it yet. I don't know if they've obtained it since, but as of right now, I don't have access to it. If you guys do, that's unbeknownst to me. But that's why I reached out. But on the 9th of February, I blocked all social media accounts that had anything to do with the petitioner's friends or family. On the 10th of February, I announced publicly on social media that I would no longer have affiliation with the company. And then I've had nothing to do with either party, anyone from the school. I let the people I was working with know, like she mentioned, I had reached out to other mermaids. I let the people that I was working with know we're no longer going to be working together, but I'm still your friend, nothing wrong between us. I'm just going to part ways. There's nothing wrong with that. That's not illegal. There were also people mentioned, like Irish Fest, Thurston County. She didn't mention the fact that it was an Irish festival, and clearly by looking at me, sir, I think you can tell my genealogy is definitely Irish. The festivals that I'm working with are 501c3 nonprofit organizations. I will not be receiving compensation. This is a gift of love to my community out of my husband's pocket, out of my free will and free time, out of my passion that I'm providing for free. I have a handwritten affidavit you may have in the room with you now. I saw my husband had entered the courtroom yesterday at the event. She's wrong about that too. The event's not tomorrow. It was yesterday. I was a mermaid for free, talking to kids about ocean conservation. And that was strictly because of my heritage. I was reclaiming my heritage, making my redheaded grandmother proud, to keep hold of something that is dying, my culture. And that's not wrong either. And it's certainly not something that I'm ashamed of or feel remorse or regret for, because I had a good time and those children had a good time. No one got hurt. And I'm so sorry, but her company is a Hawaiian themed mermaid company. The next festival that she's speaking of, the one that she's saying that she lost out on, it's Cascadia Ren Fair. Cascadia Ren Fair is a Gaelic and Celtic style fair where their actors actually learn how to speak Gaelic because it's a dying language, teach it to their kids, and do entire shows that are historically accurate in my dead language. That's a beautiful thing. And I've got a handwritten affidavit from the co-director of that Renaissance Festival where she in her own wording states that they put out a call to action in the mermaid community, sourcing free mermaids, and the fact that I was Irish was a plus, and that's why I'm being brought on to that project as well. As for the insurance fraud claims, I have not performed for pay since January 1st at the casino that Trish mentioned. She paid me $165 on the 31st at 10:16 p.m. And that was the last form of payment I've received to be a mermaid. So also saying I wasn't her employee and that I've had nothing to do with her is a little outrageous when we've been in contact since June of 2025, we were in the news together. There's a news article, Jolt News covered Olympia Harbor Days, her mermaid school's right in written paper. There's proof that for months I've been working with her, and now, I've even had to go through and apologize to the professionals that allow her to do her job because I was being taught incorrectly. I was being allowed to do things in the water, not only with my own body, but with children that put us all in danger because I wasn't the one permitted to be in the water. She's an instructor, not me. And I also have, if you don't mind, assistant mermaid instructor. Ono Wahine Iana Mermaid School. Authorized to assist in mermaid classes, supervision, and safety support. It's just a piece of paper because none of that information on the bottom is true. I was not authorized to do any of that legally or otherwise. Not by the facility that houses, the school that she provides, not by her business because I was not qualified, and not by the Scuba Association. So
At
I
this
wanted
point,
to.
Ms. Hagan, I'm gonna
Mhm.
stop you from further argument at this point or further testimony. I have pretty good understanding of what is going on here. Before I make
Yes,
my
sir.
ruling, I have a few questions for Ms. Malone.
Yes, sir.
Ms. Malone, when you indicated that she used your name and your insurance and then solicited any contracts, did you file a cease and desist letter of some sort to stop her from doing that?
I physically told her to stop using my name.
Okay. And you said that you have now lost contracts with such as Point Defiance and other entities.
Yes, sir.
Have you considered filing any claim of damages against Ms.?
No, I just want to be
Hagan?
left alone. So I want it to stop so I can just continue with my life and business.
I
don't like
understand
the
you're
legal
asking
stuff.
for a no contact order, which requires as Commissioner Stowell earlier indicated to all the parties present on Zoom and in seeking this type of show that there is an annoyance and in continued harassment to such a degree that it is causing substantial emotional to the petitioner. And then you also indicated earlier that she has been stalking you. You have given me some information, but what I have to find is that that stalking is that harassing conduct is shown with the intent to frighten, intimidate, or harass in a person knows or reasonably should know that the recipient will be intimidated or harassed. I have had
The judge delivered his final ruling, explicitly rejecting the petitioner's request for an anti-harassment protection order. He distinguished between the harm suffered and the legal remedy sought, directing the petitioner towards civil tort remedies rather than the protection order mechanism. The hearing concluded with the judge signing the denial order and transferring remaining matters to Commissioner Stillwell. Washington Superior Court Civil Rule 65 governs injunctions, including protection orders, and requires courts to balance the equities while ensuring that any injunction is narrowly tailored to address actual legal violations. Under RCW 1014-080, a denied protection order petition may not be refiled within 1 year unless there is new evidence of harassment, preventing repetitive litigation. The judge's suggestion of tort law remedies refers to causes of action, including defamation, tortious interference with business relations, and intentional infliction of emotional distress, each requiring different elements and proof standards than protection orders. In Taskett v. King Broadcasting Co., 1986, the Washington Supreme Court established that tort remedies for reputational harm require proof of false statements, actual malice or negligence, and damages, significantly higher barriers than protection order petitions. The judge's ruling demonstrates proper judicial restraint. Rather than stretching the protection order statute to cover a deteriorating business relationship, he identified the appropriate legal avenue for the petitioner's grievances. The petitioner's losses, lost contracts, damaged reputation, emotional distress, are classic tort damages, but they require proof of wrongful conduct under specific common law or statutory theories, not merely the serious annoyance standard of RCW 10.14040. By denying the order, the judge prevented the criminalization of conduct that, while harmful, lacked the specific intent and pattern required for harassment. The one-year refiling restriction under RCW 1014-4080 now protects the respondent from immediate renewed litigation absent new conduct. This ruling safeguards the boundary between civil and criminal law. Protection orders carry criminal penalties for violation. When granted inappropriately, they transform civil disputes into potential jail sentences. The judge's clear articulation of alternative remedies educates both parties and viewers about the structured nature of American civil justice. Different harms require different lawsuits, and no single legal tool resolves all conflicts. This precision prevents protection order statutes from becoming all-purpose conflict resolution mechanisms, preserving their life-saving purpose for genuine harassment victims.
You have provided the information that she blocked social media so you couldn't see, but that is not harassment. That is not a stalking. You also said that she's making contact with third party and they believe they are being harassed. Have to make a finding to order a no contact order, which can subject a person to a criminal liability. I have to hear more evidence of continued annoyance, harassment as listed as elements in the statute. Do you have anything else to add before I make my ruling?
It's just that harassing me through third party, going to the vendors and, like I said, was using my good name to make herself look better, I guess, is how I can, I
understand with your
saying
situation, and I think it is a complicated situation, but the relief that you should be seeking is not before court for in form of a no contact order, which subjects person to another criminal liability. If you have a loss, suffered any losses that can constitute a civil action against a person, you are free to explore into that. Not finding by preponderance of the evidence that a no contact order is proper based on the evidence before me, showing that the conduct is such that it seriously annoys a person, harasses, or is detrimental. It is definitely, I can understand it may have caused you financial losses
and emotional losses,
and emotional distress, and maybe reputation loss, but those are called tort law remedies that are available to you. So at this point, I am going to deny you. So we are concluded with this matter, and remaining matters will be handled by Commissioner Stillwell. I'll sign off on this order.
Yes.
Thank you.
Oh, no, I was talking about for this.
Yes, the rest of you on Zoom, Commissioner Stillwell will be.
The Thurston County Superior Court denied the petitioner's request for an anti-harassment protection order against the respondent. The pro tem judge found that the petitioner failed to meet the preponderance of the evidence standard required under RCW 1014-40, specifically lacking proof that the respondent's conduct was directed at her with the intent to intimidate, frighten, or harass. While acknowledging the petitioner suffered financial losses, reputational harm, and emotional distress, the court determined these injuries constituted potential tort claims rather than statutory harassment. The judge explicitly directed the petitioner towards civil remedies, including potential claims for defamation, tortious interference with business relations, or intentional infliction of emotional distress. The order was signed and entered on the court record. No bond was required, no custody issues were implicated, and no further court dates were set for this matter. Commissioner Stillwell resumed handling of remaining calendar matters. Under RCW 10.14080, the petitioner is barred from refiling based on the same conduct within 1 year unless new evidence of harassment emerges. This case illustrates the fundamental constitutional principle that courts may not criminalize conduct without clear legislative authorization and proof of culpable mental state. The protection order statute's intent requirement, borrowed from due process protections, ensures that individuals are not subjected to criminal penalties for ordinary business disputes, personal conflicts, or expressive activities protected under the First Amendment. When courts rigorously apply these statutory elements, they preserve the separation between civil and criminal law that prevents the state from becoming an instrument of private vengeance. The case also demonstrates how specialized legal remedies, properly confined to their intended purposes, maintain public trust in judicial institutions while ensuring genuine victims retain access to meaningful protection. If you found this case analysis valuable, Subscribe for more educational breakdowns of real court proceedings and explore our playlist on civil protection order standards across different jurisdictions. Share your thoughts in the comments. When should business disputes stay out of protection order court? Thank you for watching and for your commitment to understanding how our legal system actually works.